Thank you, Mr. Chair. Committee. After hearing the testimony, I think it's necessary for me to say.
You need to give us your name.
Yeah, I'm sorry. My name is Lynn Kamen. I represent the Family Law Foundation. I am a board-certified family law attorney out of Houston. I've been practicing family law for 28 years, and I don't think of myself as a vulture.
And you're against the bill.
The foundation is respectfully against the bill. And with Chairman's permission, I'd like to go through some of the reasons why.
Sure.
First of all, I think there's a misconception. Under our family code now, parents can agree to share joint rights. Now, joint rights are different than, as we say in Texas, possession or visitation. So let's address the joint rights first. If parents can agree when they get a divorce to share rights, the court will approve that because our family code dictates that the court should approve it. The reality is sometimes that just doesn't work. In a perfect world, divorced people would be able to sit down and decide where's the best place for our children to go to school. Where is whether our child needs psychiatric or psychological help, we need to decide that together. Right now, if parents cannot agree, what the court has to do is make a decision. Should the parents have the joint decision right on each of the rights and duties, and each one is thought about individually? Should the parent have the independent right, or should a parent have the exclusive right? So the judge, if the parents cannot agree, is going to hear evidence. Which parent has historically made educational decisions? If historically the parents have been able to agree on education, the court is going to appoint them as joint decision makers on education. If one of the parties, mother or father, is a doctor and the parties can't agree on medical, it's very likely that the court will appoint that parent who's the doctor to make medical decisions. Our family code encourages agreements. Now, but if there can't be agreements and there's a presumption that everything should be jointly made, what could happen is the following. We have litigation that continues. We've heard testimony that people have been in court over and over and over again. But if you have two parents who are unable to make good decisions and put their children's needs before their own, the following could happen. One parent says, I want our child to go to private school. The other parent says, I want our child to go to public school. The school semester's getting ready to begin. They cannot agree. What happens? They have to go into court for a modification. So from the very beginning, we're creating problems when parents can't agree. As for periods of possession and access, and let me clarify something. I have practiced law for 28 years. I have seen as many fathers as mothers, and I personally have represented as many fathers as mothers in pursuing custody, if custody is needed for the right reasons. So I do not think, and I can't speak for every judge in every court in every county, but most judges are going to listen to testimony and determine what's in the best interest of the children. We're looking at periods of possession and access. How do you have, and I think that Representative Riddle brought this up, how do you have a parent who lives 20 miles away from the other parent get the children to school at the right time? Are we doing the 50-50 because it's in the best interest of the parents, or are we going to do what's in the best interest of the children? If parents
Ms.
are,
Kamen, that's the alarm.
okay,
You need to wrap it up.
I'll wrap it up very quickly.
All right.
Our concern, and when I say I mean the Family Law Foundation, is very concerned that we're not looking at what is in the best interest of the children, and we're not realizing that our family code already protects the rights of parents and lets them make their own decisions if they're able to. Thank you.
Any questions of Ms. Kamen, members? Mr. Pena has a question.
Hold on, that's my mic. How many times have you gone to court representing parents who's been denied visitation rights to their child?
I have had that happen on multiple occasions. I file an enforcement, and if there's an underlying order that requires that the child be turned over, the judge will hold the party withholding the child in contempt. I've also had it happen very often. When that happens time after time, a judge will switch custody. And let me say one other thing, because I heard this said. If a parent exercises what we now have as an expanded possession order, that parent has 47% of the time.
Oh, you can't testify in the audience now. You have to testify only at the microphone. So thank you.
Did I answer your question, Representative?
Well, I think it happens a lot more often than what you stated. Okay.
Thank you, Ms. Brian Hughes. President Hughes has it.
Thank you, Mr.
Yes,
Chairman.
Representative.
Thanks for this, and on that, I was going to ask you about that. So, and let's, based on the expanded possession order you're talking about, at the 47%, what does that look like with stuff like school, some of the stuff, the concerns that were raised about 50-50? I don't do family law. I have a civil practice, and I don't know much about this, so help us understand.
So what happens is, in an expanded possession order, the parent with whom the children do not live primarily, during the school year, has every Thursday night overnight, every first, third, and fifth weekend beginning at on Friday when school recesses or at 6 p.m. at that parent's election, and returns to school the following Monday morning. Now, if a parent is unable to get the child to school on time on Monday mornings or on Friday mornings, then that parent, we would hope, would say, I can't do it.
Okay.
But so far, an expanded possession order has, in most cases, worked.
And so with the expanded possession order, then the parent who's getting that Thursday plus the weekend, they would then they make up the time in the summer, I guess.
They get 30 days in the summer.
Holidays.
They get 30 days in the summer, where the custodial parent does not get the 30 days in the summer.
Okay. Thank you. Thank you, Chairman.
Representative Britton.
Under current law, the non-primary gets what percentage?
I believe it's 47%, but I'm not going to debate that right now because I
It's
have
somewhere around
It's
47, 48, somewhere in that.
When you
pretty,
look-
pretty darn close to 50%.
When you think about it, it's every Thursday night overnight during the school term, and every first, third, and fifth weekends from Friday to return to school on Monday. And that's why the legislature, I think, decided that it is in a child's best interest to have an expanded SPO so that the non-custodial parent does have that extra time. But it's not as disruptive for the child.
So but 47, 48, that's pretty darn close to 50.
And if a parent lives outside of 100 miles, it's even more. It's over 40 days in the summer.
Okay, thank you.
I'll watch this now. Okay, any other questions of Ms. Kamen, members? Ms. Kamen, thank you for being here.
Thank you very
for
much.
your testimony. Chair calls Adrian Gonzalez